Our final case on the docket today is Niles versus the State of Florida.
May it please the Court, William Sheppard together with Elizabeth White on behalf of the appellant Peter Niles. This is an appeal from the denial of a motion to dismiss filed pursuant to the Sixth Amendment to the Constitution for failure to provide a speedy trial. The Sixth Amendment provides...
Counsel, do you want to reserve time for rebuttal?
5 minutes, Your Honor, I'm sorry. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy a speedy and public trial. The United States Supreme Court in Barker v. Wingo laid out the rules for determining whether a person had been deprived of that right. It's a four-step process. Length of the delay from the time of being charged to the time of apprehension, which in this case was 8.5 years. The individual was charged in January of 2000. Absolutely no effort whatsoever, nothing, other than the filing of a capias and an information. The information with the clerk, the capias in a file cabinet at a sheriff's office. 8.5 years later, when Mr. Niles was proceeding to transport himself across the border, he was arrested, despite the fact that he'd been in and out of the country in that 8.5 years, 5 prior occasions. Bear in mind that 7.5 years of this was post 9/11, so that at any time you cross the border, if there is a warrant for your arrest in the system, you will be arrested, as Mr. Niles was 2 weeks after Homeland Security happened to pick up this warrant and put it in the system. The reason for the delay is the second step. Here, the reason for the delay is the government did nothing to apprehend someone accused of a crime. The Sixth Amendment is peculiar. It not only gives us accused rights, it also gives the public rights. The public for the government to diligently pursue folks that are accused of committing crimes so that they can be apprehended and prosecuted. The third factor under Barker v. Wingo is the demand. Mr. Niles had no knowledge of the charges until he was arrested in August of 2008. And within about 60 days, he filed a motion to dismiss.
Excuse me, the state argues, as I understand their brief, that it's really not logical to conclude that the appellant did not learn of the charge because of his connection with the victim's father. They conclude that he must have learned, and therefore the various acts of trying to avoid being served was based in part on that knowledge. Would you respond to that?
Yes, it's pure speculation. This is de novo review. There is no presumption of correctness on this order because there were no findings of fact, despite an invitation to make said findings of fact, which only resulted in chastisement of counsel for asking for a findings of fact. So you review the record, and if you can find it, you will find something that I believe does not exist. There is no proof. And when you think about it, everyone that is accused of a crime, or not everyone, but as we know, the vast majority of the folks that are accused are probably guilty. Well, everyone that ever was accused of a crime knew they were guilty, so what are they supposed to do? Go tell the government, I committed a crime, I want to demand my right to a speedy trial? No, that's not the law, that's not the rules set forth by the Supreme Court, not the rules followed by the 11th Circuit or the 5th District Court of Appeals. The 5th District Court of Appeals. The fourth factor in determining a violation of an accused right to speedy trial is prejudice. Historically, it was required that an accused prove that they were prejudiced. Usually it would be pretrial apprehension, the rigors of pretrial incarceration, but over the years that evolved in 21 years ago, the United States Supreme Court tweaked the rule by deciding a case of Doggett v. United States. And what it says is that if there is an inordinate delay, and Doggett court said approximating a year, and if you figure it out, cipher it out, it's about 14 months, then you trigger this analysis. Why was there a delay? Government negligence, government bad faith, or just what? Well, this is government negligence in its best. Bureaucratic incompetence. So, because of the inordinate delay, the Supreme Court in Doggett provided a rule that you must presume prejudice. The reason you presume prejudice is because the defendant, because of the passage of time, can't prove that he was prejudiced. So let's shift the burden. The government must prove that the defendant is not prejudiced. And you can't, so you create a presumption. And in this case, that presumption should squarely protect the accused who's been denied his right to a speedy trial.
I'm sorry, did you just say that the state under such circumstances is not able to prove that the defendant was prejudiced? And that's why the presumption exists? So what I'm hearing is it's an irrebuttable presumption of prejudice?
No, it's rebuttable, but they didn't rebut it.
Oh, okay. So you're not saying that the state cannot, under any
No,
circumstance?
no.
Okay.
No,
I
ma'am.
understand.
No, ma'am.
You're saying that in this case they couldn't
No.
prove that there was no prejudice? But just out of curiosity, was there any prejudice to your client?
In my view, yes. There were several items that were urged below. But if you have a presumption, you don't have to prove something beyond what you enjoy by virtue of the presumption. And the reason for the rule, if you read Doggett closely, is because an accused can't – how can you prove what your prejudices were from 8.5 years ago? How can you? You can't. The government can't prove you weren't. So we will create a presumption so that folks in your position can intelligently rule with a set of rules that we can all –
Oh, but see, that's what I just asked you. You've said it again. You said that the presumption exists because the state can't prove that you weren't prejudiced.
Right. So it's a presumption.
So it sounds like it's irrebuttable. It sounds like that's what you're arguing.
Well, I suppose in a case, I haven't found one with this type of inordinate delay, other than when there was unequivocal proof that the defendant or the accused was a fugitive. And there are cases where a person's committed a fraud crime and they've been operating under an alias, knowing that they were going to be committing the crime and that they were going to try and avoid apprehension. Those are the types of cases where the government has carried the burden to reverse that presumption. Now, let's look at what the government knew when they filed the information against Mr. Niles. This is incredible, and I urge you to think about these facts. They knew his date of birth. They knew his Social Security number. They knew his address. They knew his telephone number. They know he was a retired military major, and they knew his employer's name, and they knew the employer's address. They did nothing. And over the course of 8.5 years, what could they have learned had they paid any attention? They would have learned that Mr. Niles bought a home in Fort Lauderdale. They would have learned that he got utilities provided to that home, that he paid ad valorem taxes, that he got a Florida driver's license. Indeed, he got 2 tickets and went to court twice. He got married in Florida. He got married, I'm not sure it was in Florida, but he resided in Florida with his wife. He voted in Florida. He was summoned to a jury 2 times in Broward County in this 8.5 years.
Counsel, if you don't mind, I'm going to interrupt you because I think everything you said just flies in the face that he was evading. I agree with you entirely. Where I'm struggling is on the prejudice prong. I was preparing for OA today and found a decision out of the 5th DCA in 2005, the Zumbrook case. I don't know if you're familiar with that, but there was an 11.5-year delay there. And that court found that the Sixth Amendment right was not violated because the defendant failed. The defendant failed to demonstrate even a modicum of prejudice. So it seemed that that court did require some actual prejudice resulting from the delay, while I think your interpretation of Doggett is that the presumption is essentially irrebuttable because of the excessive length.
Well, I'm not familiar with that case, but I would suggest to you that there was more in that record than there is in the record here. And I don't know what it is, so I'm not going to speculate, and I apologize for not knowing that case. But I do know, I believe, what Doggett holds. Doggett holds that in extreme cases, the defendant may establish a Sixth Amendment violation even in the absence of a showing of actual prejudice. Page 652 of the U.S. Reporter at 505. In footnote 1, the court relieved the defendant of any need to show actual prejudice given the cause and extent of the delay, the cause 100% the state, as you've said, the extent 8.5 years, which is precisely to the moment what Doggett's delay was. The court stressed the 8.5-year delay in arresting the defendant was a product of government negligence, which is the only thing you can find here, and that the delay was 6 times in that case in Doggett because they knew where he was 2.5 years of the 8.5 years, but this one is 8 times, as long as is generally sufficient to trigger the Barker v. Wingo analysis. I reserve my time.